Time now for Night Court. Google again under fire for alleged race discrimination and retaliation. Arden Wilberg claims that he was fired from his job as a recruiter for YouTube after he complained about the company's hiring practices. He says he felt they unfairly discriminated against white and Asian men. He claims the tech giant set quotas for hiring underrepresented minorities and deleted emails and other records of the so-called diversity requirements. Let's bring in our legal eagles, Emily Campagno, a former federal attorney, and Kent Zimmerman, contributor for the National Law Journal. Great to see both of you tonight.
Hey, good to see you.
Thank you.
All right, I'll read a little bit of the complaint. He says for the past several years, Google has had and implemented clear and irrefutable policies memorialized in writing and consistently implemented in practice of systemically discriminating in favor of job applicants who are Hispanic, African American, or female, and against Caucasian and Asian men. He went on to say the policy, the purpose was to achieve diversity in the workforce and to manage the public relations problems they were having about underrepresentation of women and minority in the workforce. So with that in mind, Kent, how do you defend Google?
Well, it's against the law. We've seen the plaintiff's side of the case, and they make, good arguments in their complaint, but we haven't seen Google's side of the case yet. And so the facts are going to matter. And the only other thing I'd say, Shannon, you mentioned quotas. It's not clear if it was goals they had or quotas they had. Goals, if they're flexible, that can be legal.
Yeah, the plaintiff says that there were all kinds of instructions, like you can only hire minorities for this next round, you can only hire women for this next round, things like that. Google says this: we have a clear policy to hire candidates based on their merit, not their identity. At the same time, we unapologetically try to find a diverse pool of qualified candidates for open roles, as this helps us hire the best people, improve our culture, and build better products. Emily?
Right. Kent's absolutely right here that it depends on whether the facts are true. And what's notable here is that in that almost 30-page complaint, there is an incredible volume of specificity and citation to actual documentation. So the complaint cites emails, meeting notes, direct messages with bosses, and cites actual policy, meaning that this is all provable. So unlike a complaint we saw earlier this year alleging discrimination against white males, that was really an overbroad, nebulous complaint. Here, it's not just allegations. There are actual specific details that plaintiff cites here that are provable. Now, as you said, Google came out today and said, no, we hire on the merits and we unapologetically are committed to a diverse hiring, but the question is just whether they go too far. And if they indeed are purging non-diverse applicants from the hiring pool that this plaintiff has alleged, that's squarely against California law. And I think that overcorrection is something we're seeing throughout the country, right? We saw it with Harvard. Asian American applicants there alleged Harvard was unfairly discriminating against federal law by not accepting them admission. That led to a DOJ investigation. So this tech case could actually be quite seminal.
Yeah, and Kent, he also says that he alleges in the complaint, there are many different people he tried to report this to say, listen, this is not a good policy. You're giving us quotas. You're not accepting resumes from white men and from Asian men because you only want us to hire certain kinds of people. He says everywhere he went that he was blown off, essentially, and that it ended up with him being fired because he wouldn't stop complaining. So now is Google facing a retaliation claim that sounds like it has some merit?
They may be facing a retaliation claim that has merit. Certainly if you look at the plaintiff's side of the case, there's allegations in there that would be damning if the facts bear them out. So I think that's an issue potentially for Google. But I also think, it has been said in court, and Emily mentioned what happens in college admissions. The courts have said you can legally consider race to try to promote diversity in college admissions. And similarly here, Google, if they're going to have a diverse workforce, that means by definition they're going to hire some qualified applicants who are white, others who are Asian, and others who are other races and come from other places. There's nothing illegal on its face about doing people alleging discrimination from minorities alleging. Yeah. And so it can't all be true is basically where I would come out on that.
And Emily, the courts have said you cannot have a quota system when it comes to education. You can consider race holistically with other factors. Could that help Google here in their arguments?
It might be. Now, remember, this is in California law, but that actually, what's interesting here, and especially what Kent was speaking about, is that Google's workforce has hovered around 91% white and Asian male for the last 3+ years. So regardless of that policy, it hasn't actually changed who they've hired. So that doesn't necessarily bode well in the plaintiff's favor. But again, if they have this written policy, that's against the law. Right. So we will see this. Note 2, he received a right to sue. It will not go to arbitration. This is headed for trial.
All right, we will see. Folks at home, tell us what you think. Who wins the argument here? How would you rule? They're the jury now. Emily and Kent, thank you very much.
You bet, Shannon.
Thank you.
All right, more news.